Right, and if we can just appoint an acting chair for the meeting.
All right.
I make a move that we appoint Kevin Guyder as acting chair for tonight's meeting.
Second.
All in favor?
Aye.
Aye.
Very good. Now, do we have a new agenda or were you working on the old one?
We're working off the same agenda we had for the work session.
All right, that's fine. So we're on the pending cases then, right?
Yes.
All right, so we start with Andrew and Dana Stone, which we've been discussing for, it seems like, years.
There's actually been a request for adjournment on Andrew and Dana Stone. Was put in by Aram at First Coastal so that they would have time to review the memorandum they received today from Chick. So it's
Okay. Can I have a motion to adjourn Andrew and Dana Stone?
I'm so moved.
Do you have a second?
Second.
All in favor?
Aye.
Aye.
That brings us down to the Community Baptist Church.
There's also a request for adjournment on that matter.
On which one?
Community Baptist Church, number 3050.
Another one's been around forever.
Then I'll make a motion that we adjourn that for the evening.
Second.
Second.
All in favor?
Aye.
Aye.
DPD Southampton was withdrawn, is that correct?
I thought that Narrow Lane was withdrawn. There was a letter.
Well, that's down in the new cases.
You gonna do decisions first?
We did the decisions. The decisions last week, right?
Yes.
Oh, yeah, well,
I don't think we have any decisions right now.
okay, well, the only thing was we demerited Choice Trust. Did we table that? Remember he asked that we don't vote on that? Did we decide anything on that? He wanted to hold the vote until we had 5 members?
Correct.
Yeah.
Did we do that? Did we do that?
No, we didn't
So
do it.
should we?
gotta
We didn't
decide.
take a vote as we were requested.
He says it's his right to wait for 5 people.
Their choice, right?
In other words, he's saying if we vote on it as 2-2, we're wrong. We can't do that, according to what John said. Now, do we agree with that? Our attorney, I think, indicated that.
Yes, and it's also been this board's policy to allow that as well. So
We have?
yes,
I think
when
John
there's
Bennett.
not a full board.
John Bennett has his hand up. Would you like to hear him at this time?
Well, yeah, just a minute. Our policy has been when a board member was absent temporarily, not when we were, say, almost permanently without a board member, or a long time without a board member, to ask the applicant if they wanted to wait or do they want a decision right then and there. Now, does that count as traditionally waiting till we had a full board? Just giving the applicant the option.
I believe so.
All right.
I believe that, and this is, I believe, the first time it would be voted on by a less than full board. So I see no issue with granting the request.
That's fine by me if it's fine with everybody else.
I thought we had said that the new member of the board would be given an opportunity to hear everything firsthand, so that there would be some type of a repeat of the presentation. Was that
Correct.
Or
Vance's
a
recollection?
review or something, yeah.
Correct. We did discuss that it would be requested that it be reopened and and renoticed with a new hearing for the new board member.
So how should we do this? Should we then adjourn this until we have a new board member when we will review the case so that the new board member is up to speed on all the particulars of the case?
my recommendation would be to adjourn it till the next meeting. And then from there, if you have a new board member by then you can make a decision. But I wouldn't want to put it out further than that if we may get a new board member by the next meeting, by next month.
I think it's-
Okay, then I'll motion that we adjourn this until our next meeting.
Do we have
I'll
a second?
second.
All in favor?
Aye.
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 Now, what does John Bennett want?
Would you like me to switch him to a panelist?
Yes, I think you better.
Okay. Let me make it so you can be seen. Hold on. John, are you with us? There you are.
Well, I wanted to speak, I wanted to speak before the motion, but that's fine. I remember what Mr. Greenwald said, and I agreed it would only be fair for a new member to be able to have, a presentation, and I have no problem with that. And I agree with Mr. Kerr's restatement of this board's longstanding policy. So, I mean, but you took the motion, and it's just fine with me because that's what I wanted you to do, and I thank you.
That's it, John?
Yep, for this one.
Okay, hold on, let me get you. 1 second. Where are you on here?
Okay,
Yeah, 1 second, let me just. Okay,
all right, John's gone.
all right.
That brings us up to South Lane properties regarding 72 Glen Lane. You ready to make a decision on this one? When we're gonna make a decision?
Say that again, Kevin?
John is,
To make a decision on South Lane properties, or at least decide when we're gonna make a decision.
I think we're at DPD Southampton. No?
No, that's.
Well, there's a note on here on 36 and 3037 Lifton Green, if we were going to remove that from the agenda, because
We did,
it's like going on a year.
we did,
That, yeah, that was removed.
it's gone.
So we did that?
Yeah,
Yeah,
Okay. So 70 Hill Street is next?
no, number 72 Gin Lane.
I think it might be what, 70 South Hill, DPD, no?
Right, I don't have that one was withdrawn.
I thought the attorney had said they were going to withdraw it, but I don't know, David, if it was done formally.
I haven't received anything formally withdrawing that.
Are you talking about 70 South Hill Street?
Correct.
But are they here tonight? Are they on the list? Are they at the meeting?
They were on the list.
Yeah, so would you like me to bring in John Bennett? I believe it's John Bennett and,
I don't think it's.
No, this was Eric Dantes was the attorney on that.
oh, Harry Contes, is that it? Okay, I don't.
3062 70 South Hill Street. The prior attorney that was making submissions was Eric Dantes.
Okay,
This last week.
I
so,
didn't see anybody signed up for that on the list.
yeah, I don't think he's in there, so.
I think we withdrew this last week, didn't we? It was withdrawn.
From what I understand, from my notes from last week, Tiffany Scarlato says that they represent the new owner and that they would be withdrawing it, but I haven't seen a formal withdrawal.
So then we can't do anything about it right now. If they're planning on withdrawing it. We can't do
Correct.
it.
I would say you adjourn it then.
We don't even have it on the list anymore. Oh, yes, we do, sorry. All right, so do we need a motion?
So I make a motion that we adjourn it for this evening.
I'll second.
All in favor?
Aye.
Aye.
Now we'll wait until, we'll see if it is going to be withdrawn or not withdrawn. All right, back to South Lane regarding number 72 Gin Lane.
Okay, let me see.
We've had this around, we've got to decide whether the man has standing, or if he has standing, he has no injury. That seems to be the issue. Or we send it back to the planning board.
Well, you would have to first decide that he is standing before you decide whether or not the building department you feel acted properly, whether or not then you decide whether you send it to the planning board.
All right, so,
This is the continuation of the public hearing was left open from the prior meeting.
so if we decide he has standing, then we can either send it to the planning board, or we can make our own decision that he's not injured or he is injured.
Correct.
Okay.
Okay, so David, could you what is our guidance with respect to whether the applicant has standing or does not have standing?
The question is whether or not he has a specific injury to be a person aggrieved by the decision.
Mhm.
It is a special injury or damage to his personal or property rights.
Okay, so let me ask this question. If I believe that his view is hindered or partially obstructed or in some way affected, is that enough of an injury to provide him with standing?
If you feel that that is creates personal damage to him that's different from the public at large, then yes.
Okay.
But he has to
Is there-
not just claim he has an injury, he has to prove it that he has a specific injury caused by this decision.
But we don't have anything in the code about views. I mean, people are building houses next to people all the time. So, I mean, there's nothing in the code about one house obstructing the view of another house, as long as you build your house to the, approved location.
Well, your code actually does include language regarding the purpose to reasonably protect natural scenic beauty and cultural and historic resources of the town and its environs.
You've got to recuse yourself, David.
So if the board feels that protecting the natural scenic beauty that's included in that purpose provision does not apply here, then that's the board's decision.
You could make that for any construction going up.
That's right.
I have an empty.
I don't think the neighbor has standing.
In my view, we approve this, we're opening up a can of worms. Anybody can get into and claim anything that goes up in their view is injurious to them.
So Kevin, I don't believe the neighbor has standing.
I don't think so either.
I went and looked at the property. I could not see. It was like it didn't drop a beach view. It didn't block an ocean view. It was like he looked at a next door neighbor's house. Like I look at the neighbor's house in my village, in the village.
I agree with you completely. This is a case.
So I don't know. How do the other board members feel?
No, I mean, I believe that if somebody has, a view of the ocean that's being obstructed, that he has some type of injury. You can debate the extent of his injury. You can debate whether or not he should, get over it. But he has an injury for purposes of the conversation we're having.
It would have to have a detrimental effect on him.
It does.
He still has his view right in front of his house. He's got hundreds of feet on the ocean. He's got a view.
He's got a view to the west also.
Yeah,
Yes.
down there several times.
May I speak to the board, please, on this issue?
There was a question as to what the other board members felt.
We haven't heard from Julia.
I'm interested in gathering as much information as I can before I have my opinion. So I don't know who's asked to speak. I can't see who that is.
This is Thomas Gibbons, the attorney for the applicant. I'm up on the screen. I don't know if you can see me or not.
Yes, we can see you.
Now I can see you.
Okay. Thank you. So just so the board understands, Chris Shumway has joined us. He is the sole member of South Lane Properties LLC. He should be on your screen. With respect to standing, as Mr. Kirsch said a few minutes ago, in order to have standing, my client has to show that he has injury separate and apart from the public at large. He's done that. Number one, we've submitted the Cushman and Wakefield report that shows a diminution in the value of his property. Whether Mr. Bennett wants to pick it apart is a different issue. Once we show injury separate and apart from the public, that's the legal standing. That's the legal standard we have standing to bring this third party appeal. And the other case law that I cited, the geographic the location between 104 Gin Lane, the property that my client owns, and 72 Gin Lane, that gives it standing as well. The case law that I cited under Village Law 7-712A, not under Town Law 267A. I vehemently disagree with Mr. Bennett. He's citing town law and saying, well, it's not a big deal. Town, village, what difference does it make? Well, let me ask you this. Are we in front of the town of Southampton Zoning Board of Appeals? No, we're not. We're in front of the village of Southampton Zoning Board of Appeals. Therefore, the Village Law 7-712A applies. And the cases that I've cited, Haran, Lashings, and other cases support the proposition that I don't need to show individual injury. But even if you think I do, I have, or my client has, through the submission of the Cushman and Wakefield report. There's no member of the public that has this house next to them. And if you can look over Mr. Shumway's left shoulder, you see that house. And I know, Ms. McCormick, I believe you said you went down to the property. And I urge all the members to do that. And Mr. Shumway would like a few minutes to speak for two reasons. Number one, Mr. Bennett has seen it fit to attack my client personally, calling him a serial objector. And someone asked during the work session, well, is he just a, cantankerous old man? And my response is, what difference does that make? Whether my client is the patron saint of Gin Lane or the devil, doesn't make a difference. He still has the ability to come before this board and ask for relief, whether he has a house on Gin Lane or a shack by the railroad tracks. You can't say, well, you know what, we're going to judge this case whether or not he's a nice guy or he's a bad guy. That's not the legal standard. If you look over my client's left shoulder, you see what that
comment. Can I speak now? Because with that preamble, I'm happy for you to judge whether I'm a nice guy or a bad guy and vote accordingly. Because I think I am a nice guy. I have been very reasonable, and what I'm asking for here is very reasonable too. If you look up my shoulder, you can see the new structure that's built. It's not a small structure. It's a meaningful structure right out on the beach dune, and it's a very different structure than the one that existed there before. Here, it is true that I have a lot of beach frontage, and so that is true, but it's also true that this property, which has been put up here, has damaged the value of our property. But don't take my word for it. I would just encourage any of you, before you make a decision on this, just to walk down to Little Plains to the beach, turn right. It's the third house on your right. You can't miss it, and just judge for yourself. Come down and decide whether you think that house being there damages our property. Now, to the issue of the real question I have, though, is why, with the covenant that existed from the planning board, why is it that the planning board has not weighed in on this and been a part of it? Because I understood it to be the case that covenant rules here. And look, at the end of the day, this is a very different situation than what we had here before. We've got a big two-story structure that was raised up. And in my view, there were a lot of other options. But in any case, those weren't pursued. This one was. But I guess what I'm looking to this group to is to help out a homeowner who, in my opinion, has a right to be protected by the law, as I understand it, which is that there is a covenant restricting this from being built. And yes, there was an opportunity to renovate, but the next door neighbor chose not to do that for whatever reason. And it would have been a different structure, and they could have also worked with me and said, hey, why don't we put in screening? Why don't we do it lower? Instead, we lifted it way up on the dune. We went 2-story high. This is not a normal situation. And for those of you who've spent a lot of time, and many of you, I know most of you have, in the village as I have, just walking up and down the beach, you'll see the difference between this and other structures on the beach. And I would just encourage you to do that.
If I may make a few more points for the board. I know that we had an extensive meeting in February and provided a ton of case law and memos, but this case is really very simple. Once you get past standing, which we have, and I know I can't ask Mr. Bennett questions directly, but I would ask one of you to ask these questions. One, is there a planning board covenant on 72 Gin Lane? The answer is yes. There's been no evidence, testimony, anything to the contrary of that. Number two, what does that planning board covenant do? It prohibits construction within 100 feet of the top of the dune. Nothing that's been offered to the contrary. So,
Oh my God.
Covenant? Yes. What is it? Construction within 100 feet of the top of the dune. The only thing they were permitted to do was put a second story on the old house, but they chose to voluntarily demolish the house. And as everyone on this meeting knows, when you have a pre-existing non-conforming structure, when you knock it over, you lose whatever rights you have. So is there a planning board covenant? Yes. Did it prohibit this construction? Yes. And the last question is, did the building inspector have the authority to override the planning board covenant by issuing the building permit and the coastal erosion permit? And the answer to that is no. I've cited 2 cases ad nauseum, Second Department, Marks and Van Dusen, that specifically say where there is a planning board covenant, only the planning board can modify it, lift it, or do anything else. And Mr. Bennett's going to come up and say, well, my client's property isn't within the subdivision. He's right. My client's property is not within the subdivision, and that does not matter. It doesn't have to be. The matter of Blyer case and the other cases he's relying on don't make a difference. My client does not need to be within the subdivision. I think Mr. Kerr said as much in the last hearing. So if there's a covenant and they're not permitted to do what they did, then how is it that the building inspector gave them the building permit and the coastal erosion permit? And the simple answer is he shouldn't have. What really should have happened, and I don't know Mr. Foster, I never met him, never had any involvement with him, but when the application was submitted to build this house, Mr. Foster should have said, well, you know what, there's a planning board covenant. So go in front of the planning board. If you want to make a new house that's FEMA compliant, then go in front of the planning board and get relief. Don't do an end run by having someone sign a letter giving a homeowner the ability to do something they otherwise would not have been able to do. Last question. If I go into the building department tomorrow with a letter for Mr. Talbot to sign, allowing my client to build a 2-story structure in the dunes, is he going to sign it? The answer is no. I don't have that right. I can't just, the process isn't that you go into the building inspector and have him give you all rights that you're not entitled to by signing a letter. The process is 72 Gin Lane LLC should have gone in front of the planning board, and they didn't. And I know you board members have said, well, why are we here? Why is this in front of the ZBA? Well, that's the way the village code is written, and that's the way the village law is written. You are the appellate body. So my argument is that the building inspector should not have issued the coastal erosion permit and the building permit. This isn't really so much about views, it is, but we're here because we're asking you, the village, to enforce a covenant you imposed on this property, 72 Gin Lane, after 4 years of litigation. And that's it. It's not about views. It is in some ways to get us standing, but we're asking you as a property owner in the village to enforce a covenant you imposed after 4 years of litigation. It's that simple. Those questions, this case is that simple.
Hey, Kevin,
Yes.
Or I should ask David. David, from what you said, the only thing we have to determine is if he was financially harmed. None of the other stuff we're talking about matters. Is that correct?
Could you repeat your question?
You said the only thing that's really before us is if he's been financially harmed, that would be give him standing. Is that the only thing that would give him standing? Is that the only thing we have to consider?
No, if the board considers the view to be protected by the zoning code, then that would be something that for the board to consider as being in his, as being a special, if he claims a special injury to that, that would be in the board's decision whether or not the claimed impact on his view is a specific injury that he's damaged by, that he has a detrimental effect on. So you have his,
And
the
well,
claims
his
of-
attorney said the value that he said that his client's property has lost value because of that house being built there.
That's up to the board to weigh whether, based on his submissions and the opposition to those by Mr. Bennett, whether or not the board feels that there's an actual financial damage.
Well, my experience, when someone builds a more expensive house next to your house, it only increases the value of the property of your house. So I don't know if I buy his financial argument.
You don't
So
have to.
To me, has he been harmed by the view? So I don't know. What do the other board members think?
But Dan, remember, he did submit an appraisal that supported the idea that he was hurt, that the value of his property decreased.
You can go out tomorrow and find somebody else who would appraise it and say it's gone up. You can't believe these appraisers. They're hired by the applicant. They're going to do what the applicant wants. You just can't believe the appraisal is inconsequential so far as
That's yeah, because my experience is that if you improve the property around your property, it increases the value of your property. It doesn't decrease the value of your property. So I'm skeptical of that appraisal.
Dan, I think what you're saying applies, in general throughout the village. I don't think it necessarily applies when you're talking about a shoreline property.
Can I be heard?
Yes.
yes.
Okay. I rarely have seen a zoning board of appeals application so full of misstatements, so full of bad legal advice, so full of going sideways. I'm gonna try to be measured about this, because there is absolutely nothing that you should do under the history of this, under the case law, under principles of interpretation, under principles of standing, under the litigation history of this thing, but send Mr. Shumway packing. And I'll tell you why. And I do not understand Mr. Kearse's decisions to the contrary. As a matter of fact, I've told Mr. Kearse that based upon his representation of an objectant in another case of mine, he has a severe conflict of interest. He's giving you the wrong advice. The advice you should follow is the advice of the Zoning Board of Appeals Council in this case.
Hold on one moment. Clarifying.
I'm not going to hold
Yes,
on any
please.
moment.
No, you will, because you're making a misstatement right now. The council in this case is for the village of Southampton, not for the zoning board in that matter. They're
right, whatever,
separate
David.
entities.
Okay.
I've discussed this with the village attorney and with the
David, let me make my
special
case.
counsel.
You've done enough unethical
Can we
things.
not
as it
raise our
is. Let me
voices?
make my case.
Can we
okay?
please not raise our voices tonight?
Just let me make my case. Please don't interrupt.
Go ahead. I wanted to correct your misstatement.
Well, you correct whatever you want. You've got a severe ethical problem here, but that doesn't even matter, because what happens here is that you're being given advice that is clearly contradicted by the black and white case law. I don't care whether or not it's in the town code or the town law or the village law. And as I pointed out in my papers, those sections are exactly the same. They're creatures of the state legislation when the state revamped all the code sections relating to Zoning Board of Appeals many years ago. And in the commentaries, Terry Rice talks about them as if they were one, because they're exactly the same. I don't understand. I'm so glad so much of this conversation has focused on the covenant, because Mr. Shumway's case is nothing without this claim of the covenant, and he has absolutely no standing whatsoever to raise it. That's the position that your counsel in the litigation involving these very facts, Campobello and Middleton, took before the Supreme Court. I gave you copies of their motion to dismiss Mr. Shumway's lawsuit, in which they say unequivocally, Mr. Shumway has no standing to raise the covenant. That's what your counsel says. That's what the Second Department says in the Blyer case, unequivocally. They say, given, and this was a neighbor trying to object based upon a covenant that had been imposed by the Village of East Hampton or the town of East Hampton, it doesn't matter. It was a municipally required covenant. I'm going to tell you later why the arguments on the covenant are BS, but regardless, they have absolutely no standing to raise this. This is the Second Department on this very issue. Given that the petitioner was not an original party to the grant and does not claim to be a successor in interest, heir, or assignee of the original party, he has no standing to enforce the grant. And that was echoed again in 2017 in Fleetwood Chateau owners. Since the plaintiff is not a party to the instrument creating the covenant, he has no right to enforce it. I've yet to see anyone, specifically Mr. Kirst or Mr. Gibbons or Mr. Shumway, specifically give case law that contradicts that case law. And I'm, to be honest with you, dumbfounded that there's any discussion in a case where I've presented you the evidence, I've given you the evidence, I've given you the case law. The counsel that the village appointed to defend against this case in their motion to dismiss this case said that Mr. Shumway has no standing. And indeed, when Mr. Shumway tried to obtain a temporary restraining order against the construction of this, the judge in Suffolk County Supreme said that he had, in writing, no likelihood of success on the merits. So I'm scratching my head. What are we doing here? Let's talk about the covenant. This covenant came out of litigation, which is res judicata. It's collateral estoppel. In the early 90s, as you know, and as I've put out, the Zoning Board of Appeals denied the request to put a second story on this house. It went to the Supreme Court. The Supreme Court directed the Zoning Board of Appeals to allow the second story. The Appellate Division did the same thing. The second story was put, there's a two-level house built on this, a new house built on this, which would be contrary to Mr. Gibbons' interpretation, which he has no standing to raise. Back in 2003. This is the third house on the same footprint. It's the second new house on the same footprint. $3 million has gone into this. Mr. Shumway had his shot, didn't get a TRO. He never went to the appellate division. As a matter of law, and standing and latches can be raised in an administrative proceeding, he has this action, this request is moot as a matter of law. When he didn't go to the appellate division second department, when his Gibson, Dunn and Cratcher, the big Wall Street firm that he hired, didn't go to the appellate division to try to get the stay overturned, of the refusal of the Supreme Court to issue the stay overturned, his case became toast. There's no question about it. I've litigated the issue directly in a case, the case involving Joe Farrell building the house on that flag lot off of Hill Street, in which case the court, by the way, that was Ann Pine, an adjacent neighbor, the court said she has no standing. And that's what the court directed. And he tried to get an injunction in the Supreme Court. He didn't do it. Never went to this appellate division to try to get the appellate division to overturn the Supreme Court. And the appellate division said, you have to keep going. You didn't. So as a matter of law, Mr. Shumway's entire application, you shouldn't even look at it. It's moot. He's subject to latches. His big fancy New York law firm dropped the ball, didn't go to the second department. His case is toast. So the appellate division has held that he has no right to enforce this. I don't know why we're talking about standing. These cases as to whether, the case as to whether or not you can have a first, second story there, that was litigated years and years and years ago. And you don't have to take my word for it. Take the word of the authorities that I have cited and the authorities that have been cited by your counsel in the Supreme Court. And let me tell you something else about this view. And this is why Mr. Kirst has an absolute, unequivocal ethical problem here. There's a Second Department case that was recently decided. There was an owner in the town of Huntington who had an application to build, and it's applicable because it interprets the New York State Code governing your manner of treating variances, which is exactly what is involved here. Judge Santorelli was faced with the decision where a guy went in, put a house, got a variance from the local zoning board, put a house right in the guy behind him's view shed, not 400 feet away, 300 feet away, like Mr. Shumway we're supposed to be concerned about, okay? Totally in his far peripheral view, totally right on the spot where it had been for 50 years, okay? Right in front of this guy's view. And he said, you can't do that. You shouldn't have granted the variance. That blocks my view, okay? There's no question about it. And in that case, Justice Santorelli, Supreme Court, Suffolk County, said, in dismissing the case, the main complaint was focused on the impact of Sclafani's privacy in view. However, there is no provision in the village code which guarantees a property owner's view, or for that matter, his privacy. He dismissed the case. The Appellate Division, Second Department affirmed, I don't know why Mr. Kirst is taking some preamble, that's not a section that you can rely on, to the village zoning code and saying that case doesn't apply. I'll tell you why he's saying that, because that case is fatal to his opposition of a case that I have in the town of the Zoning Board of Appeals on Crescent Way. Exactly. It's fatal to it. He shouldn't have taken that case. He's put himself on the horns of a dilemma, and now he's giving you advice that's contrary, specifically contrary to the position that the village has taken, which collaterally stops him from doing this, contrary to what the village has taken in their motion to dismiss this case against you. I don't know what we're talking about this on and on and on for. The matter has been decided. The case law prohibits his standing. I have also have cases that I've litigated. The Shinnecock Indians they were adjacent landowners. They bought a case against a subdividing client of mine. The court, affirmed by the Appellate Division, said, we don't care that you're the adjacent homeowner. You have to show actual, specific, legally cognizable harm. And by the way, that Cushman and Wakefield thing is about 80%. They made the mistake of getting an out-of-town appraiser. We tore it apart. And not only that, our appraisal showed the two largest transactions in the village of Southampton that have happened recently, both of which I handled. Both of those people bought oceanfront property with a fraction of Mr. Shumway's view that were blocked by houses right in front of them. So you know something? Mr. Geiderer and Mr. Guzowitz are right. If you start doing this and recognizing the fact that somebody builds a house in an appropriate area, in an approved area, an area that's been approved for over 20 years, and say they have standing, then everybody has standing. I have a neighbor who built his garage is 5 feet from mine. They added on to it. Do I have standing? I wouldn't have the temerity to come in that I have standing, let alone somebody with 400 feet of oceanfront complaining about a house that's been reconstructed in the same place and is higher only because the federal government has told them that it has to be higher and the building inspectors told them that it has to be higher so it can meet the FEMA laws. So really what you should do is close this, make your decision, read the case law. David, I'm going to ask you again. I think you have a massive ethical problem. I think the board should get other counsel because you put yourself on the horns of a dilemma. I think you should close this case, make a decision. There's absolutely no proof whatsoever. I would ask you to ask Mr. Gibbons and Mr. Kirst What case law has overruled the Blyer case and the cases we've cited where in order to have standing to enforce a municipal covenant, you have to be in the subdivision? Think about the chaos that you would be enabling. You know something? I live a mile away, but that's a covenant in there. And I'm nowhere, no, forget a mile away. I don't live in the subdivision. I live across the street. But you know something? I don't like something that you did, so I'm going to go enforce that covenant. That's not the way the law works. That's not the way. All you have to do is look at the case law. So I'm going to ask you, what cases have been submitted that contradict the Blyer case and the other case that I just talked to you about, brand new cases? You ain't in the subdivision, you have no standing. And understand this, Shumway's case doesn't even begin to fly without some sort of standing to raise the covenant. He's got none. Your own counsel has said that. The judge back in the fall looked at all of us, including his big fancy Wall Street firm, and said, I don't see any standing here. I don't see any likelihood of success on the merits. If you want to go to the appellate division, you better hurry because they're building. And that's exactly what we've done. We built in good faith. We relied on the building permit. As you can see from the current affidavit, we're 80% done, $3 million in. Mr. Shumway's counsel dropped the ball. Mr. Shumway should call up Gibson, Dunn, and Cratcher and say, is Bennett right? Do I have a problem because you guys didn't go to the appellate division and ask the appellate division to institute the TRO when the Supreme Court, Suffolk County didn't? Because if they're going to be honest with him, they're going to say, yeah, that's a big problem. Now, I've had cases dismissed 8, 9, 10 times when somebody had a problem. They sat there, they either didn't seek relief for a TRO, or they sought it in the Supreme Court, didn't get it, and then didn't go to the appellate division. That's exactly what happened in the Joe Farrell case. The judge dismissed an adjoining neighbor's complaint because she had no standing. Talk about being in her view shed. It was right there. She didn't have 400 feet of beachfront to enjoy. Judge said, listen, you know something? Pretty much, if you've got a problem with that, go buy 100 acres in the woods. This is absurd. This is absurd. All you do is enable people to continue and complain about their neighbors doing stuff that is fully permitted. I've been, all of a sudden there's a rash of these in the last 5 years. I walked out of one of these hearings after the judge, again, denied a TRO, and I was walking out and he motioned me here. Come back. And I said, let me get my adversary. And he said, no, I just got a question to ask you. What the hell is going on in Southampton and East Hampton? I have all these applications for TROs on single family residents. He looked at me and said, what is the Fed printing too much money or something? This is insane. How come you people can't get along? I'm not going to entertain these sort of things. And you know something, Mr. Geiderer and Mr. Guzowitz, you've got it. You understand it without all my submission of case law, but I ask you to read it. And let's get this thing closed up. Send Mr. Shumway down the road where he belongs, and he should enjoy his 400 feet of beachfront without bothering my client.
Can I speak now, please? So I appreciate that long soliloquy. So the first thing that I would say is it's this property, once they knocked it down, they had the choice. They could have renovated it according to the covenant, but once they knocked it down, just as I have several structures out back behind on the dune right now that are for pool equipment, they were built 80 years ago, I could, by that theory, then just knock those down and put up FEMA compliant new structures. But my understanding, and you all tell me if it's not correct, as soon as you knock the building down, you're in the business of getting permits, and to get permits, they had to go file for those. They can't go straight through an inside deal where they go down to the head of plant, the chief building inspector, and get a Joker is wild permit that says you can have variances, which is what they did. And then they built up a 2-story house. I wouldn't have had any problem if they had just followed their existing covenant that they have and put on a second story on the house where it was. But as soon as they knocked it down, it turned into this, which may be hard for some of you to see, but I would encourage all of you, walk down to Little Plains. It's a beautiful walk. Come check out and see what it looks like, and see if that looks like a little cabana that they had there before, or something diminutive like it was. At the end of the day, we have been damaged, as the attorney has told you. This, and as our property report shows, we have damages, and they're legitimate damages. Now, I get where Mr. Bennett is saying that, well, he's got a lot of footage, so don't feel sorry for him. But I don't think that's what this is all about. If we're now able to just knock down and put up new cabanas, I assume that when others come for a permit who have no existing status on the dune, they would get approved under the same theory. If we approve this, in my judgment, from what I can see, then I would assume others would have similar rights for putting up new buildings on the dune. And so I would just say, number one, I don't understand why the planning board never got involved. It seems quite unfair to me, and it seems that it didn't make sense to me that you went to the chief building inspector. But I would argue that that was an inside deal, and to me, that's a very frustrating position. But that's what happened.
By an inside deal.
I mean, that the chief building inspector should have never issued that. That was not his position to issue. He knew it was not his position to issue. He was pressured by others.
And the house is no longer the issue. The house is not the issue here. The issue is whether you have standing or have you been harmed. I don't care if the house is a tower. It's not the issue.
I'm reflecting Mr. Bennett's claim that it was fully permitted. With all, excuse me, with all due respect, I'm talking about Mr. Bennett's claim that it was a permitted application to put that house, which I would disagree with. But I agree that it's this.
It should have been bought then, when they went to the building inspector and they got the permit. The house is up. It's there. The issue is, do you have?
Yeah, I agree. I agree that the house is up, but in my view, in my humble view, what should have happened the whole way is it should have gone to the planning board. To the extent that you all send it back to the planning board and vote it down today, then we could have talked about reasonable things like, why don't they put up a hedge in between us? Why didn't they screen it? If they're going to build a non-conforming, new, very high, unusual structure for the beach, which I would encourage all of you to look at, because you're in the position of approving these kinds of projects going forward. And I would just want you to see, is that the kind of project that you want to stamp your name on a go forward basis?
So you say you like screening. How is the screening going to help? You're complaining about your view, and now you want screening. Screening's not going to change your view. It's not going to give you more view.
What it will do is take what was a small cabana into a second floor tall building that sits right on the dune, and now I can look out and see them from my backyard, in my window, in my pool, and it is a significant structure that has changed the value of our property. And if it was there by right, I get it, but the question is, was it there by right? Our view is no. It clearly is not there by right. So it requires an approval to get a variance that should not have been issued. That's the point.
I think we should
Can I interrupt about screening, because there's a screening plan. There was a screening plan by Arnie Maynard, a world famous British, architectural, landscape architect, that was approved by the ARB. It's on file. I don't know why Mr. Shumway hasn't seen it. We put a significant new screening along to the east side of this, as approved by the ARB. They never attacked that. They never did anything like that. It's there, number one. Number two, probably 6 or 7 months ago, I spoke to Gibson, Dunn and Cratcher, and I said, you know something, instead of all these two neighbors beating themselves up in the Supreme Court and the Zoning Board of Appeals, this thing is done. You guys didn't go to the appellate division. Would you please speak to your client does he want some more screening, whatever? Oh, that's not going to cure anything. You really want me to go back with that? So maybe, again, you should talk to Gibson, Dunn, and Cratcher, and maybe you should look at the file, because there was a very significant landscaping plan augmenting what's there, which we submitted to the Architectural Review Board. It was part of the condition and part of the approval. It was the landscaping plan by Arnie Maynard, approved. Again, I tried to see if there's some way so that, go ahead. All you're going to do is keep paying the lawyers. So I tried to put money into doing some screening there, some additional screening.
John, this is not about paying lawyers. I have no interest. So you all are the only ones who want to get paid. I'm paying. I have no interest in paying anybody. I do have an interest in being heard in what I think is an unfair situation. I think.
Well, you stated that you needed a variance that the variance should have been granted for that house to be built there. But from the testimony we got, the house was built in the exact footprint, actually a little smaller footprint, that there had already been approval for a second story, and that the new house was just built to the FEMA regulations that the federal government requires now. So I don't think there was ever a variance required from our board for them to build that house.
If I may, I think respectively, Mr. Shumway may have gotten a couple terms confused. There's a covenant on that property. What the homeowner should have done is gone in front of the planning board and said, hey, we want to build a FEMA compliant 2-story house. They never did that. That's what this case is about. They got to sidestep the planning board. How did that happen? I don't know. A letter signed by the building inspector that Mr. Bennett wrote doesn't get you around the planning board. That's what should have happened. If this 72 Gin Lane LLC wanted to build a 2-story house, they should have gone in front of the planning board, the only entity that can lift this covenant. So it's not a variance. And that's what that August 2016 letter signed by Mr. Foster says. Well, we don't need a variance. Okay, a variance from what? A variance from the zoning board or whomever doesn't lift that planning board covenant. The simple fact is, and Mr. Bennett is going to smoke screen you with talking about
smoke screen. You're the smoke screen. You're trying to get them to ignore the law.
No, I'm not. I'm trying to get them to follow the law and follow a covenant that they imposed. You want to look at
you have no standing under the case law. You haven't submitted one case contrary to our authority. Not one, because there is not one that exists.
When Mr. Bennett spoke, I didn't interrupt him. Unfortunately, his
lying. That's why
he does not give everybody the same courtesy. He attacks my client and speaks over me. He spoke, I sat there. Learn some professionalism. You want to read a memo that's rife with improper law and improper facts? Read your own. I'm asking to enforce a covenant it imposed. It's that simple. The only way that covenant gets lifted is in front of the planning board. And Mr. Bennett sat here and said the federal government forced them to do that. The federal government forced them to put a second story on the house? I don't think so. As Mr. Shumway said, everybody to take a look at the house and see.
Kevin, I have a question. I'd like to refer to Kevin and David. So from what I understand, originally there was a house there that was granted to be built when they did the planning board approve this. Then 20 years ago, they went into the building department and they said they wanted to tear that house down and build a new house. And the building department gave them a permit to do that. If somebody should have gone to the planning board, it probably should have been at that time, because now that house that was built 20 years ago was torn down, and now this house is being built there. So I see ancient history here. This should have happened 20 years ago, not
now. I'd like you to close.
Question? I'm not sure. I mean, yes, I agree. That's the time frame that occurred. And whether or not the current building inspector in issuing his new permit followed the precedent of prior determinations. And if you feel he rightfully interpreted the covenant and that precedent and issued the permit, that's well within your purview.
Let me
That's
ask
sort of how I see it.
our attorney. Let me ask David a question. As John says, do you have a problem with this application? Do you have an ethical problem or a conflict of interest?
No, I do not. I discussed this with the village attorney and with outside counsel.
You don't?
No, I do not.
I'll renew my objection.
If this board would like to find that views are not protected by the village code, they're within their rights to do that in this matter. I'm not stopping you or letting you, that's your decision.
Okay.
The matter cited by Mr. Bennett and Scalfani, the Village of Northport Zoning Board decided that their code didn't protect views. Their code is different than your code.
Oh, come on.
Okay.
Let me respond to that. What the case says is that you have to have a specific provision creating view shed protection. There is no such thing. The preamble stuff that David cited is in the town code, the village code. All it does is lay out the purposes for zoning. That's all. It's not a specific creation of a view shed protection, which is what you would need. So yes, I'll agree with David insofar as it's your determination, and you should make that determination that the village code doesn't have any view shed protection in it. If the village trustees wanted to legislate that, I'd be the first one to stand up and say they shouldn't, but I guess it may be under their powers in the municipal home room law, but it ain't there.
And it doesn't need to be, because I'm not here arguing that the village shouldn't have granted a variance.
That issue
The
was
word
litigated.
variance, I'm saying
years ago.
that the village should enforce a covenant. The Scalfani case cited by Mr. Bennett, like all his other cases, don't apply. I'm not arguing the zoning board of appeals shouldn't have granted a variance. I'm saying a house shouldn't have been built in direct violation of a planning board covenant. End of story. Do not pass go. Do not collect 200.
And in any event, you're far too late. You went to the appellate division. You went to the Supreme Court. All you did.
I didn't go anywhere. I sat here in my office.
Too late.
And I'd just like to let the board know, Mr. Bennett and the attorneys, that I've requested the lower court decision in Blyer. Because as I've previously stated, that was a hybrid action. It wasn't a straight Article 78 determination. So I've requested the underlying decision in that matter to see if it supports the claims by either Mr. Bennett or Mr. Gibbons. As I feel the other matter, the Fleetwood Chateau, was not an Article 78. I don't feel that is on point. But to reach deeper on the Blyer case, so I've requested that. Unfortunately, with the county being shut down and non-responsive, I've yet to receive that to see what the underlying decision had in that matter, as that was a hybrid action. So I've requested those
whatever it's
underlying
worth.
papers.
For whatever it's worth, I spoke to Anthony Tohill, who was counsel on that case, and he says he didn't understand how this application even begins to withstand the impact of Blyer.
I'd like to hear what Julia has to say of this. She's been pretty quiet on this, and I'd really like to hear what she feels.
Julia, you're muted.
Frankly, I'd like to hear the underlying pieces. I'm finding the case law that's being cited and that I have read. I'm confused about where we are. I happen to share the same view that I believe that Mark also shares, which is that view there's an impact on that property, but I don't feel as though I have enough information. I'm not an attorney. I can't shift through all of these cases that are being cited to us in a facile way. I can hear them, and sometimes the way the advocates are presenting can be confusing as well. So I'd like to get as much information as I can, but I am very aware that since the time that this was brought before us in February to now, we've gone from looking at a construction site to an almost finished product. And when you say, David, that you're getting the Blyer information, I'd like to know that. I'd like to have that guidance as well.
Yes.
David,
Yes.
the neighbor tried to block them from continuing, and the court allowed them to continue construction. Isn't that the case?
That's correct.
That is the case.
That's incorrect.
That's
They asked for a TRO. to stop the construction and the court denied it.
Right, but we still have, Gibson Dunn is still litigating an injunction. And so there's two things, a temporary restraining order and an injunction. The court has not heard the injunction, and Mr. Bennett told you the judge, said this. Well, the judge was a woman, and she never said half the things he said she did.
You weren't there.
Village council agree with anything. The village's attorney, as Mr. Kurz pointed out a few minutes ago, Mr. Bennett is trying to mix apples and elevators. What's going on in the Supreme Court and what's before you are two different things, two different sets of controlling law, and he's trying to mush it all up as, again, I said, it's a smokescreen.
Let
So
me read.
Kevin, I think we're
let me
getting
read
buried
you-
in lawyer speak.
By the way, Mr. Gibbons was not there. I was.
I read it. I read the
No.
transcript.
You
I can-
weren't there. And let me read from you. Please let me finish, because this is right to the point. I'm reading directly from the motion to dismiss Mr. Shumway's case involving these very facts. The petition must be dismissed because the petitioner lacks standing, does not have the standing to enforce the restrictive covenant, does not have standing to enjoin any zoning charges. There are none. The mootness doctrine bars judicial review. He's gone. He waited too long. Latches. The petitioner's challenge to the construction of a 2-story house is barred by collateral estoppel. This is your lawyer speaking. Issuance of the building permit was proper. Talks about this litigation was gone and decided 2 years ago, as Mr. Guzowitz said. I'm not making this stuff up. This is what your lawyer said. And this is what I've presided, given case law for. And you know, they want to talk to you. But let me finish, Mr. Gibbons. You told me, you criticized me for interrupting you. Let me finish. Because someone has a harm, a self-perceived harm, doesn't mean that's a legally cognizable harm. That's where we are in society, I guess. If I feel aggrieved, then I must be aggrieved. Well, you know something? The law, thank goodness, has created very strong requirements for you to demonstrate that you're aggrieved as a matter of law. And you know something? The Supreme Court judge didn't think so, didn't issue a motion for a TRO. And you know something? When Mr. Shumway's lawyers didn't go immediately to the Supreme Court Appellate Division and ask for a stay of that, it was game over. There's three, and that's a administrative as well as a judicial defense. And you should, if you don't feel comfortable, then you should ask your own counsel that's been appointed by the trustees to inform you on that, because there's $3 million in on this, reliance on the building permits, covenants that no one has the standing to enforce, never went to the appellate division. That's exactly what the case said. The second department said in the case regarding the Joe Farrell house on the flag lot off of Hill Street, where Ann Pine brought the case. She sought a stay. They didn't give it. She didn't go to the appellate division. The appellate division said, we don't really care about the substance of your argument. You blew it. You didn't go ask us to overturn the Supreme Court and stop the construction. So the judge found no likelihood of success on the merits. She even said, you better go to the appellate division. If you get there fast, you might get there. She was sort of chiding them. And they never went. I was so sure that they were going to go because I knew that they had to, that I drafted papers in opposition for the appellate division, and they never went, and they never went, and they never went. And I'm just going to say again, Mr. Shumway, you should ask your counsel at Gibson, Dunn, and Cratcher, what is the effect of them not going to the appellate division on an expedited relief, that's the terminology, to try to have the appellate division impose the temporary restraining order. They're duty bound to do it. They didn't. They have an insurmountable latches and mootness defense, which is a defense. These defenses, I litigated this issue, matter of Hadlin, all these defenses I can raise in the administrative theater. So I would ask you just to close this. Let's get this done. Let's get my poor client on her way, let her build as she's been building. No one's shown any standing. No one has shown any legally cognizable harm. That's the key. You can't just say, I'm aggrieved, therefore that means you're aggrieved. You have to show harm that the courts have recognized as harm. So please close this and make a decision.
What's the opinion of our board members? What would you like to do? You want to hold this open? You want to close it for decision? Those are the two choices. Personally, I'd like to close it to decision, but it's up to you.
I could see closing it, but if Julia and the other board member want to further discuss it, we could hold it over and just talk it through at the next work session.
Well,
I would
on behalf of the
appreciate that,
applicant-
but I would like the opportunity.
I want to
when
hear
we're-
from you. Go ahead.
I'm sorry, Dan. I would appreciate that very much, but I would very much also like to ask that we have the opportunity to actually discuss it amongst ourselves. There are a lot of different components to this, and I would appreciate the exchange.
Okay. So
I could see that. I would go with that.
adjourn this for all purposes.
So move.
Okay, we would ask that a decision not be rendered until a fifth member has been appointed.
Adjourning it for all purposes.
Okay, thank you.
You're asking a thing about the fifth.
I want to make sure that I've heard that. So Mr. Gibbons is asking this board not to take an action.
No, I'm asking for, as you did in a case, I'm asking for a
you.
fifth board member to be appointed like you did.
That's okay.
Just be aware, I fully intend to use that against you in the Supreme Court. You again have asked that this case be adjourned. All you're doing is piling on your insurmountable latches.
All right, we got that. We have a motion. Do we have a second for the motion to adjourn this for all purposes? We don't have.
Did
a
I motion? Who made the second? Yeah.
I'll second.
I'm in favor.
All right, there's a second. All in favor?
Aye.
Aye. It's adjourned for all purposes.
Thank you all for your time. Appreciate it.
Thank you.
Okay, 1 second. Let me pull these out and then we'll pull in the next ones.
Yeah.
Are you checking in?
The next one is Easo Realty LLC, 145 Cooper's Farm Road.
1 second. Let me just take out the rest of the attendees.
And that had paperwork that came in this afternoon, correct? Additional paperwork.
Haven't seen that.
Okay. Policeman. Okay. Mr. Kriegsman, you're on.
Good evening, Alex Kriegsman, 279 Main Street, Sag Harbor, on behalf of the applicant.
Okay.
And Mr. Rollins or Mrs. Rollins?
Sorry, I was muted. Good evening.
Okay.
My name is Morgan Rollins. I'm the architect for the applicant.
Why are they?
What's the issue here?
So this is Alex Kriegsman. We are seeking relief from 116.17-1, which is the maximum GFA. My client's been, I know it's just, looks like just an LLC, but our client's been living there for more than 10 years. She is looking to expand and put on, for her family, and put on a second-story addition. Doesn't want to change the existing footprint. As the board is probably aware, When she bought the property, she would have been allowed to do this, but the max GFA has tightened up. And so that's the issue. That's what we're seeking. I would respectfully submit this is a pretty modest project that she's talking about. It's not substantial. I don't see this having anything more than a negligible impact on the neighborhood. And it would make a big difference. For my client, it's not a very big house to begin with. She's not looking to make it a very big house, but just looking for some extra space for her family. And so I'd respectfully submit that we satisfy those factors. I know there was a work session. It's been a couple of work sessions, and it was our impression that this got sort of a favorable view the first time. Last time there was some skepticism. I think some board members might have stated they want to see there was a good reason for this. It's just that she's a growing family and just looking for some more room. And I think you have available, I think we have the architect here. It's really beautiful design and consistent with the character of the village and the neighborhood. And respectfully ask that our application be granted.
So the reason is that she wants more space, right?
Yes.
Is it only one variance? Is it only a GFA variance?
I think that's right, yes.
Yes.
There's no pyramid law variance.
Who just spoke? I missed it.
So what I'm asking is there a pyramid law variance, or is it only a GFA variance?
Only GFA. We accommodate the pyramid law. We're not impacting the pyramid law, the envelope.
But you're asking for over a 10% increase in floor area over the maximum village allowable floor area.
Yes, we are for the current code. Yes.
And the village just changed this code because I think the village thought that houses were getting too big on small lots. And so they decreased the floor area code to minimize that. And so now you're coming in and just say, well, disregard that new change that the direction the village wanted us to go and let us have this larger space.
Yeah, we're getting into an area here that's quite sensitive. The zoning has been changed, and people are going to come along after the zoning's been changed and ask us to violate the zoning. I don't know whether we can do that or not.
Well, by necessity, anyone who is here is asking you to do something that the code doesn't allow them to do.
Yeah, we understand that.
I don't know that it's fair to disqualify us on that grounds. And I think it's very relevant to point out that she's been living in this house, and when she bought it, this is something that would have been permitted by the code. And I think if you look, one of the factors is supposed to be the impact on the neighborhood and the impact of the community. And if you look around this Cooper's Farm Road, you look around the neighborhood there, I don't think anyone is going to suggest that what we're proposing to do is too big of a house. We're not talking about anything along the lines of the prior application, the kinds of houses those folks are living in. This is a modest house, and this is someone who's been living in it for more than 10 years and is someone who is seeking something that was permitted when it was purchased. And so I think that's a set of facts that would distinguish this from someone who's just coming along and said, oh, I know you changed the code, but that ought not apply to me.
Maybe the application ought to have been done years ago instead of being now.
She didn't have the money.
Have you submitted elevations and floor plans, or do I just not have them?
Yes, we have. We have a whole package of plans and elevations. I'm not sure why you don't have them.
I don't have them. I think that we should have.
I think they were last seen in March.
Excuse me?
I think that we were given them in March.
Yeah, I don't know. In my paperwork, either they're missing or they weren't part. I'm missing that folder. So I would like to get a set of the plans.
Well, all I can tell you is
Zoom, if you're going to, pull them up.
We submitted them. We were told our submission was complete. I mean, this is the first that we're hearing that something.
Oh, I guess what I'm asking is, are you prepared to present the elevations, the plans, and the floor plans to show us and to walk us through what you're doing and why?
So Morgan, the architect, is on as well, and I don't want to speak to the technology there, whether it has the ability to do that. Morgan, is that something that you have the capability to share with the board now over this Zoom meeting?
I mean, it would be pretty rudimentary. I would point my screen at the drawings.
Okay.
If that's acceptable.
Let's see if we can see your screens.
Okay, so you'll lose my face and I'll walk you through the drawings, okay?
Very good.
And you can just talk to me if you can't see it. All right, how are we doing so far?
Well, I can see the cover sheet.
Okay, that's a start. All right, so this is the plot plan. Like Mr. Kreisman mentioned before, we are not increasing the footprint of the house. We're only renovating the second story. So there's some, just kind of a thorough set of drawings. This is the first floor. So you can see this is called the existing demolition first floor plan. So you can see there's very little being demolished because there's only a dash line for a new front door that the client would like. Then we get to the second story. So there's more extensive work. Can everybody see what I'm?
I see the floor plan. Point out what's new.
Okay, well, this is the demolition. So let me go to the proposed for the second floor. All right, so this is the existing elevations. And then, so here's the proposed, this is the proposed second floor plan. So we've, one of the weaknesses was that there weren't adequate bedrooms on the second floor she has 4 children. And also one of the members of the family works at home, or needed a home study. So we built over the garage. That's the new footprint on the second floor, or part of the new footprint. And then this study area is the second part of the new footprint, which allows us to increase this bedroom size. And then I'll show can I flip to the elevations?
Yeah.
Okay.
Yes.
So this is the new addition over the garage.
Show the low. I only see the top. Lower it down. Let me see the first floor.
Sorry. There's the west exterior elevation that faces Cooper's Farm Road. So you would see an addition over the garage from the street. And then we modified this gable at the entry. And then this is kind of the study that we've added on the right side of the page. And then this is, I'm going to go above for the north elevation. This faces the neighbor. I think that's 147 Cooper's Farm Road, or 143. But that's the addition over the garage again, and we did this attractive Juliet balcony. Let's see. Sorry, and then this is, so this is facing the other neighbor. So that would either be 147 Cooper's Farm Road, and they would see this kind of a little bit of an addition to accommodate the home study.
Is that where the railing is there? Is that where it is?
Yeah, exactly. And then beyond, again, is the other side of the garage.
Deck?
Sorry, I'm
That's
sorry.
sort of an outside deck there with that railing?
That's correct. Should we go to the floor plan again?
All right, so the study has a door that goes out to an outside deck.
Yes, not to get too personal here, but one of the homeowners is a smoker. So that's why they would like to have this deck, but the deck doesn't count towards the FAR,
And the room over the garage also has a deck to the facing?
Yes, that's correct.
road?
So, I think it's going to be a little bit more attractive house.
And the deck is overlooking Cooper's Farm Road?
This deck, yes,
Over
the
the
deck
garage.
for the garage. Can I go back, flip the page?
And sure.
So this facade that says proposed west exterior elevation, that faces Cooper's Farm Road.
I'm not seeing your video anymore.
Yeah.
Oh, shoot. I pressed it by accident. I
There you go.
apologize. Okay. So I don't know if you get enough.
How deep is that deck? Is that like a 6 foot, is the roof over? Is it?
It's not extending over the footprint of the existing garage. It's about, I think, 4 feet wide, but it's almost a
The
full
roof does
width of
not
the
extend
garage.
over it.
Excuse me?
The roof does not extend over that deck?
No, we haven't made, the second floor footprint is not larger than the first floor footprint. It's a modest, I mean, I'm sorry, I didn't mean to interrupt.
No, I'm saying there's no ceiling above that deck. In other words, you didn't extend the gable out
No.
over the deck
Here,
area.
you can see over here on the, this is the north elevation.
Okay, I see it.
I do think your drawing should show the pyramid line.
Hold on one sec. Oh, shoot.
I believe we have submitted that, just for the
Yeah,
record.
we did submit it to the village, and they said, I forget the history of it, but we do have a drawing, and because we were in compliance, I mean, I could easily get that to the board. Can I,
I have a copy of that in my file, so I'm sure we can get it circulated.
great, that would be great. I'm
Thank
sorry,
you.
I lost you guys again. Is it okay if I go back to myself?
Yeah, we're looking at you.
Okay.
Actually, hold, if you give me a moment here, let me, I'm gonna hold it up on my video here.
Pyramid law?
This is the pyramid diagram.
Great, thank you, David.
All right, so that shows no violation of the pyramid law?
Correct.
Yeah. One side doesn't even seem to be even close, and the other side is close, but it's not violating.
Right, and the side that's closed, that's where the addition is,
Right. So
primarily.
this shows the addition within the pyramid law, not violating.
And the room above the garage, based on the floor plans, is going to be another bedroom?
Yes, that's correct, another bedroom.
You have any other questions?
I don't know, just how the board feels that like they are adding floor area, but they're not increasing the footprint. But that he is increasing massing, so that's the question. Have we done that before?
No.
No, we did it, well, we did it recently over on Halsey.
Yeah.
For this much, this large of a request?
Well, yeah, that's the question. Let's look at that.
What do you want to look at, Mark?
Well, no, I just, let's compare. We did recently provide a variance to the GFA law over on Halsey Street.
We did.
Yes,
What Dan's asking, and I don't recollect, is how large of a variance that was compared to how large of a variance this is in this case.
So that's the question.
I have that decision here. Let me see. That was 299 square feet.
This time it's how much?
474.
400. 474.
So a little less than double.
Isn't a better way to look at that as the percentage increase?
That would be interesting, yeah. What would be?
That, let me see, that,
Saying that this is 10%? Is that what you said before, Dan?
Yeah, well, a little bit more than 10%. Because, you know, the original square footage of the house was 4,085 square feet. With the additions, it'll be 4,559. So they're increasing it like 500, you know, square feet. So a little over 10%.
Okay. And the one on Halsey Street was not 10%.
it was 299 square feet. There was a currently existing 3239.
So you turned out pretty close to 10%.
Yeah.
Just under.
And that house was already over GFA by the new code change.
So that, it sounds like the board allowed them to increase the degree of nonconformity there.
We did.
Well, I would respect that that's relevant, and then again, just reiterate that the impact on the community and the design of the house are relevant factors here for the board to consider.
You know, you did have one deck on the study that sort of faced the neighbor's yard rather than the street. I don't know what the necessity of that deck was.
That was for the smoker.
Yeah, thank you. Yes.
But yeah, I mean, I don't know if it's our venue, you know, our purview, but the deck's overlooking the street. I mean, you know, the ARB may have a problem with that, and I'm not sure we don't, but we can talk about that at the work session. The idea of having decks overlooking the street.
That's something that is in your purview in this request, because they can't put that deck where they're proposing it without you granting the relief for the additional square footage of interior space.
Right.
Well, is a deck facing the street more or less harmful than one that faces the neighbor?
I think we might have a problem with both of them.
Okay.
I think that it increases the usage outside of the floor area. So like you were concerned about mass and use, here you're increasing the use interior, but you're also increasing the use on the exterior.
Right.
Well, one of the decks, if I may speak, one of the decks, the one over the garage, is so we didn't increase the footprint of the interior space. So it didn't make sense to kind of stop short of the footprint of the garage. So that's why we thought it was an attractive solution to have a small Juliet balcony, because the house is a little bit nondescript without these. I understand your concern of the one that's by the neighbors, but we did notify all the neighbors regarding our package to the Zoning Board of Appeals, and
You've had no opposition.
that's correct.
That just seems unusual on Cooper's Farm. I don't know if there are any other second floor decks overlooking the street. I mean, are there?
I can't think of one. I have to go down the street. I go down that street 4 or 5 times a day, and I can't think of one.
I have one in my house, but it was built in 1982.
I mean, we could certainly look at removing the deck. If that's kind of a fulcrum for whether this goes ahead, we could certainly look at removing the deck over the garage, another design solution.
And I just
How
want,
much
but
would
not
that
adding
reduce
square.
the square footage?
It wouldn't, because it's exterior space. So I think
It
we're
just
talking
reduces the
about,
mass. It doesn't reduce the GFA calculation.
yeah, I think we're talking about the Architectural Review Board, correct? Or
Yeah,
yeah, if I could just,
you have to go there anyway, right? You have to go there.
yes,
Maybe the ARB could deal with the deck. I mean, it doesn't
Just,
worry.
I just wanted to emphasize Mr. Rowlands' point is that the decks are there because we're trying to minimize the floor area in the house, and they're there instead of living space. And I think that's an important point.
That's a good point. Yep.
Yeah, but it could be roof line instead of deck.
Well, maybe, but the point is that we're seeking relief from the GFA law, and it's showing that we are trying to minimize the amount of relief that we are seeking and trying to minimize the GFA while trying to provide as much space for a growing family. I know everybody comes before these boards and says, oh, I'm not a developer and this isn't for spec, this is for me, but this is someone who's actually been living there for more than 10 years.
No, I mean, 477 square feet expansion is still significant without making the deck internal space. So I think what we're talking about is eliminating the deck, but of course not adding additional square footage.
Well, look, as Attorney Kirst stated, that is a relevant factor for this board, and I would agree with that. And we'd prefer not to remove the decks, but the applicant is looking to move forward, and if that's a compromise that needs to be made in order to be able to move forward, I think that's something we'd be willing to look at.
So then, how many bedrooms do we end up with on the second floor? I know plus the study.
I'm sorry.
5?
5?
Is that right?
6.
6.
6 bedrooms, not including the study.
How many bedrooms now?
There's one less bedroom. There's 5 bedrooms. Yeah.
And a study besides, right? So actually,
Well, there's this study there now, but it's much smaller.
They have a finished basement here too, with bedrooms and playroom?
No bedrooms in the basement.
And any bedrooms on the first floor?
Yes, there's one. Let me just confirm. There's 1 bedroom on the first floor.
So that's 7 bedroom.
That's correct, but she has 4 children. 4 children, and then.
how's the parking? Does she supply the parking for 7 bedrooms?
Well, the kids are too young to drive, but
You still have to supply parking, but 7 bedrooms, you have to supply the parking, whether they're driving or not, whether you have cars or not.
I wasn't aware of that. So we need to provide 7 parking spaces?
6.
So you
Well,
have 2 in the garage and probably 2 outside the garage. You would have to provide 2 more parking spaces somewhere on the property.
Yeah, I would just respectfully submit, that's not in front of the board right now. We'll, of course, going to comply with whatever the code requires in terms of parking.
But we would like to see where that parking is going to be.
Well, excuse me for a sec. I'm pretty sure that you could fit 2 cars. Again, I'm not familiar with the parking code, so I apologize. But you could fit 2 cars behind the 2 cars on the asphalt driveway. So you could fit 4 cars on the asphalt driveway.
Yeah, so you need 2 more.
Yeah, we'll have to check.
No, we have the garage also. So we
We'll
have
have to check with Chris to see if stacked spots like that, how he counts them.
Okay.
That's a question you're going to have to answer.
Yeah, I'll speak with Chris about this.
Okay. Do you have any other questions?
I'm wrestling with it a little bit because it's a need that the applicant has. You're saying they have 4 children.
That's correct.
Okay, and they have 6 bedrooms on the second floor.
Mm-hmm.
Well, if you look at the demolition plan.
And plus a study on the second floor.
What happened was they They split a bedroom in half to make currently the 6 bedrooms. They split a bedroom in half. And one currently it's a study. So they're trying to give all things, you have children, you want to make everything equitable. So they're trying to make equal bedrooms for all.
Yeah, no, I mean, not to, I'm just trying to measure the need, because you have 6 bedrooms, you have 4 kids, everybody gets their own bedroom, you still have an extra bedroom plus an extra bedroom on the first.
That's correct.
Am I missing something?
They have a nanny and a housekeeper, or if they have guests,
Oh, okay, I'm just trying to, it's not just this case that comes up. I mean, we would have plenty of GFA, variance questions coming up, and just trying to measure, balance things out. Kevin, I'm fine as far as if you want to adjourn or whatever you want to do. I'd like to talk about it at the work session.
Okay. I have a motion to adjourn this for all purposes.
I'll move. Can we join for all purposes?
I'll second.
All in favor?
Aye.
Aye.
Okay, thank you, members of the board.
Okay, let me take them out.
That brings us down to the new cases.
Well, that was actually the first time you heard that one.
It was the first time. I don't know how it got up on the cases. Unless it got adjourned once. Maybe it got adjourned early.
Kevin, this is Chick. I had emailed earlier today just to see if 500 Captain's Neck could come up early in this segment.
You want us to do that first?
If that's possible, that would be great.
That's possible, right? No one objects to that, do they?
No.
So we'll start with 3073. Chickamauga LLC, 500 Captain's Neck Lane.
Okay, I'm going to bring in the if you're here for this case, can you raise your hands? That makes it a lot easier for me to promote you to a panelist. You want to be heard on this, on Chickamauga? Great. And let me all right. Melissa, you are in. Mr. Dropkin, you are in. Mr. Jarrett, you are in. Okay.
All right. Who's before us on this case?
Are we on?
Yes.
Okay, all right. You can, thank you, Chick, because I was just eating my dinner, my nuts. Good evening, Melissa Dedovich, Peconic Environmental Associates. I'm here on behalf of Chickamauga. That's the way you say it, LLC. And it took me a long time. We've going for ARB and everything to learn it really well. I'm joined with members of Larry Wiener Associates. I believe Andy is on, as well as Ethan and Matt from Reese Roberts, the Landscape Architects. To cut to the chase, I think to just boil it down to what it is, since it's already been a long night, is we would like to restore the existing wetlands and take 1.1 acres of existing manicured fertilized lawn and create it into a naturally planted as a wetlands restoration. That's pretty much a nuts and bolts of it. This is an almost 7-acre property. It has a large expanse of existing lawn. And then I'd like to give it to Andy, who I believe is on, who will walk us through. I think we have our plans also uploaded, if that would help, Chick, or do you think it's necessary to go through the whole project?
Melissa, I think some type of graphic just to show the basic, color rendered plan that
Okay.
provides the restored area.
Well, why don't we start? If we're going to do that, let's Andy, if you can put on the screen, if Julie can, or I'm so sorry, I don't know who's actually running this, but if we could share the screen with Andrew.
Yeah, I can't share the screen. You have to do it from your end.
Okay, Andrew, are you on?
Yes,
Andy?
I'm here. Do I need to request? There we go.
Let's see.
The share screen at the bottom. Just we did have everything uploaded. This is our first time that I've been in a webinar. Usually when we've gone on, they've had them already uploaded.
Yeah, I do not have them on the
Let me
current
see if I can-
that I'm currently on here.
I could try to bring them up, Melissa, if that helps.
Okay, that would be very helpful, Matt. If Matt could.
Is that visible now?
That's great.
Yeah.
Okay, I was able to do it. This is
Okay, the area that's being shown, I'll have Andrew, is actually, we were gonna show the existing site conditions, but we're just jumping to the chase here of the whole area and all this. And Andy, if you could walk them through it, that'd be very helpful.
Yep. So the area that you're seeing now, starting from the bottom of the page and moving up. The bottom of the page, the blue hatch is existing wetland along Taylor Creek. Right now, it's currently 50% Phragmites, common reed, and 50% native marsh. We would be proposing in this area to manage the existing reed canary. To the left of the blue hatch is existing shrubland that is primarily native. I believe in the documentation that we provided the board, about 90% of that is native shrub. The green hatch above the blue hatch, up right there, is an existing sort of marsh grassland area that I think we also have somewhere in the area of 90% native, with some mix of Phragmites in that area. And again, something we would be seeking to manage. Moving above the marsh area, where you see all of the sort of colored hatches, what's not being shown by the screen resolution is a meadow mix that we intend to install on the property. It's approximately 1.1 acres that will become native meadow. The existing conditions in that area is currently managed turf grass. That is, I believe, currently mowed. It's a combination of native and non-native grass species with a few common turf weeds, including plantain, which I believe is probably the dominant broadleaf weed in that particular area. The 1.1 acre meadow that we'd like to install in that existing turf grass will be all native species that can tolerate the soil and hydrologic conditions of the site. The colored blobs and hatches that you saw on that plan will ultimately be live native plants that we will install in various container sizes as part of the project as well. The intention of those live plant drifts in the various colors is to provide some aesthetic uplift to the site in key locations and along key views, but also to help usher along the meadow establishment, as that is a much lengthier process, and the addition of native plants can oftentimes help kind of hurry that process along for us.
And there's some driveway going through that 1.1 acres, right?
I'm sorry?
There are some driveways going through that 1.1 acres?
Those those are maintained pathways, just, those are gonna be native grasses, but they're gonna be mowed. So,
Walkways?
I'm sorry?
Walkways. That's
Paths, right?
Walkways, pathways, yes.
And leading down to a dock.
Correct, existing dock.
Okay.
So this area is going from an area that's mowed down to a non-mowed area?
That's correct. So the process for establishing a meadow like this, we generally tell people it's about a 3-year process. In the first year, to reduce weed pressure, we would mow this area, the seeded 1.1 acre area, every 4 to 6 weeks. The intention there would be to keep weed growth down and allow the seedlings to establish and grow. In the second year of establishment, we generally try to get to 1 mowing a year, as by that point, the seedlings have established to a point where they can suppress problematic weed growth. And then in years 3 and on, we generally have one mow a year that will occur in the dormant season, depending on the client's preference. That can be anywhere from November to April.
So just to clarify, Mr. Guzowitz, it will be maintained at least once a year, just to keep out any non-natives and to keep, weeds from taking over. But it is planned to be a native restoration, which presently isn't there, that would contribute to the existing wetlands that are there. There's beautiful wetlands. I'm sure Chick can tell you along the shoreline. There's just certain spots that need to be taken care of and remove some of the invasives there. But it really is going to be a beautiful restoration project.
Are you going to have to put in temporary irrigation to get this started and then remove it? What's the deal on that?
We would, for the seeded portions, we would not require temporary irrigation. Very rarely do we use irrigation on seeded meadows. I think that depending on when the live plants go in, those colored blobs on the plan, we may institute some temporary irrigation in those areas to help the live plants establish. But in the 1.1 acre seeded area, the seed mix itself would not require irrigation. It's really just those colored areas. And depending on the timing of that installation, we would be able to limit the amount of irrigation required. So if we installed the plants, say in fall, we'd be taking advantage of back-to-back seasons, fall and spring, that are generally cooler and have more sort of natural moisture.
But we're not expecting to having permanent irrigation once the meadow's been established.
I have a question for Chick. Chick, for the other plantings besides the meadow grasses, did you review the list? Do you agree with what their planting list indicates?
Thanks, Dan. We had a couple of minor comments. I don't know if Melissa has seen the memo, but
We weren't provided a memo.
Say that again?
We were not provided a memo today.
Okay, we'll make that available to you. The board had it just before the meeting. And we just had a couple of recommendations on possible, plants that we feel are not native that could be improved. It's a pretty minor thing. We can certainly go over that with Matt and look for your input to see if those comments can be addressed. I did want to mention a couple of things. We did flag the wetlands in 2017. As Melissa said, it is a nice wetland area. I do note that the setbacks of the village are shown on the plan. And overall, this is the type of plan that we would strongly encourage because it is removing fertilized lawn. It does seem to me as though on average, the 125-foot setback area is probably receiving more native vegetation than if the entire 125-foot was revegetated. In other words, this area is not being revegetated, and I was going to ask why, but this area is.
Yes.
And again, that removes lawn area and provides native habitat for wildlife and removes nitrogen-dependent vegetation. So overall, it's a great plan. We have also asked in the past the purpose of the trails, because that does reduce the native vegetation area. But I have to say again, overall, we like this plan very much because it does remove lawn. We'll make a memo available on a couple of items. Maybe I can pull it up here. This is the memo. It's dated June 25th. It identifies the materials that were reviewed, and then a couple of comments about the seed mix with one of the species and a couple of the non-native main meadow mix, salt tolerant mix, and accent areas. And in most cases, the natives should be available, and these are just cultivars that there should be commercially available natives available.
Hey, Chick, they mentioned that they were going to manage the Phragmites. Do they specify how they're going to manage them?
We do look for that. I'll let Melissa comment on that. I believe I saw a plan for that purpose, and that has to be done very carefully.
There is a plan. There's a management plan. It needs to be updated a little bit because we thought we were going to be heard in March. So work was already going to be starting in May, but it's very easy to adapt, and Andrew can walk you through that as well.
So the management plan, I think, for the Phragmites in particular, we would be looking to, in the documents that we submitted, we were recommending that we perform a mow of all the Phragmites, or cutting it to the ground in June. And then waiting approximately 6 to 8 weeks, in which time we would go back into the site, wick apply herbicide to impact only the Phragmites. And then the following year, next year, repeat that process again in July and I believe the fall, September. That process would repeat for a third year, and the wicking of the Phragmites is only happening one time in 2022. And that generally provides us with adequate control that in subsequent years we can move to a once a year wick application of what we hope to be limited regrowth of Phragmites.
And actually, if I could clarify too, actually, it's not a mow, it's a hand cutting and hand wicking. Also, Chick, if you could be so kind as to put up on the screen the existing, I specifically had the team do an existing conditions map that actually highlighted where the Phragmites that were going to be affected and how limited they are. This is not a hole where we have Phragmites like 50 feet deep and 100. They're actually, each of these areas, and these were all in your packages, specifically address where each of these different, you can see, where everything is and where the common reed and to be removed. So it's really that patch that's over there at E2 that really is what we're talking about. C is a beautiful Spartina patent, and Spartina altiflora is there. It's the majority of the wetlands look beautiful, but I think what happens every time, and Chick will also comment, is that if you leave this alone, the Phragmites end up choking out the rest of the natives that consist of the rest of the shoreline. So we'd like to get a grip on this section here.
So once you get a grip on that Phragmite, will the native species then rehabilitate that area?
Correct. That is correct. We're hoping they will outcompete it.
A very legitimate approach, Dan. That's been done in other cases, and we would certainly recommend it.
And also, Chick, I'd just like to thank you for acknowledging that we do have more than 125 feet of the buffer that it looks, you know, we always try to get clients to encourage them to do projects like this. And by doing that staggered, it just looks much softer and more beautiful on that piece, on that particular piece of property. I think having it straight across line just looks odd. So we overcompensated on the right-hand side to allow a little nice flow into where the pathways are over there on the left-hand side.
I think this is a wonderful plan, and that you've addressed all the issues that I can think of.
Melissa, or Matt, could you explain the paths and whether or not, whether both of these paths are needed?
Sure, I could talk to that. So the client specifically asked for pathways throughout the entire property. He likes to walk and talk on his phone. So that takes up a good part of his day, and he just wants to be able to walk through the meadows and down by the wetlands and enjoy, the entirety of his property. So that's why we had multiple paths going through there. So he has options and, has the ability to go through different parts of the meadow.
And how will those be, what will the ground cover be in those areas?
It will be the same meadow plants. They'll just be mowed. We have done situations where we put turf in pathways, and the turf doesn't work well with the meadows just because it's a sod. It creates a sod, and it kind of overwhelms the meadows on the edges. So working with Larry's team, we've discovered that doing just a mowing of the actual meadow plants is the best way to create pathways.
And I see some look quite wide. These days, it's a little tough to plot plans and scale them, but can those be 4-foot paths?
Yeah, I think at the end of the day, 4 foot is perfect. We just want it so that two people can walk, side by side together down the pathways. And I think 4 foot's adequate.
Okay, that is not in the comment memo, but if you could make a note of that, we may look for a couple of minor revisions to the plant list. And if you could just address that for any updates. And I believe Melissa said that the management plan would have to be updated as well.
I'm sorry?
We're going to update one of the plans because the hearings have been delayed because of the virus.
Oh, it's just a time frame, the management plan. That's all. And I think we looked at it yesterday or the other day as a team, and I think it just means that we're going to be starting a little later. But we can definitely update that, and we can make the changes to the plant mixes very easily. And if you would like us to, there's two ways. Either we can adjust this plan, or you can put as part of a condition, as part of the wetland special permit, that the pathways are limited to 4 feet in width. That might be an easier way to do it.
Yeah, I'll be honest. I do like the plan, but I did not have a decision prepared for tonight. But we should hear from the public at the chair's direction. But in cases like this where we don't have structures and it's a purely beneficial plan, we do like to move them along. And, it would be very easy to have a decision, if that's the board's wish, for the meeting. And if you have those plans in prior to the work session, we can just button everything up and have that decision ready. Sadly, I guess you'll probably have to wait till fall to plant, would be my guess.
Don't worry, we're still building the house. We got it. If I could just ask, so if you are in agreement, then the only thing we'd have to revise then is just the plant mixes and the methodology, and we'll just put, instead of us changing this, we'll just leave it, we'll just put as a condition 4 foot wide path limited to 4 feet, or do you want us to change this plan as well?
Well, we can minimize changes. If there are other changes, then make the change on the plan. Otherwise, we'll do it as a condition.
Perfect. Okay. And we can have that to you within the next week in time for the work session.
So we can close this for decision?
I have nothing further. Kevin, is there an opportunity to hear from the public, or?
Yeah, if we have any public out there, we can hear from them right now. Do we? It's
the only
makes it a little bit hard for the format to
yeah,
the public to get involved, but if we have any public, we'd be glad to hear from them.
they had an opportunity and they weren't part of the list of attendees. So the only attendees for this application are those that are currently on the panel.
Okay.
So the opportunity was provided.
Yes.
Okay, that counts. So, Chick, shall we close this one, the decision, as Dan just said? Is that what you want us to do?
Yeah, I don't expect there's a need for further input. I will, with the board's permission, transmit that memo to Melissa and Matt so they have it, and we can work out the final details of what looks like a very good plan.
Very good.
So then I make a motion that we close this for decision.
Do we have a second?
Second.
All in favor?
All in favor?
Aye. Very good.
Thank you very much, and have a wonderful evening, and thank you for getting us out early.
Hey, Melissa.
Appreciate
Take
it.
care. Have a nice
Haven't
night.
seen you in a long while.
I know. It's been this pandemic, the darn virus. I'll see you soon.
Very good. That brings us up to 3069 Morse and Connors, 24 Osborne Avenue.
Okay, one quick second. Let me get you switched out. If you're here for that case, could you raise your hand? It's Victor Pruzanowski. That's it? Okay. Anyone else for this application for Morse and Connors?
There's no one here for it?
Yeah, there should be. Okay. Let me add you to promote to panelist. Okay, anyone else for this case? All right, hold on one second. And okay. You guys are panelists now, Mr. Pruzanowski and Mr. Morse. I think you have to unmute yourself, Mr. Pruzanowski.
Yeah, there you go. You hear me now?
Yes.
We hear you, but we don't see you.
Okay, I'm pressing the button here. So
Hold on one.
I've been waiting for 2 hours and now I screwed it up. Well, can you hear me?
Yeah, we can hear you.
You can't unmute yourself? I mean, you can't start your video?
Video yourself.
All right, so how do I do this? Is speaking.
You go to, there should be a button that says start video next to maybe unmute.
Okay, I'm just joining the website. Hold on. Oh, Christ. I waited 2 hours. I just had a Zoom thing last night. I am not a robot. What is that? Join the website. All right, let me come on again. Oh, for God's sakes. You hear me?
Yeah, we can hear you.
Shit. Thing worked perfect yesterday.
Do you see a button that says start video or anything along the?
I'm gonna do it right.
Here, let me see.
I see a thing that keeps coming up. I'm not a robot. What is that?
I have no idea what that is.
I know.
Here, let me help you out. Now see if you can do it. Can you do it now?
I'm having trouble here, Brenda.
I sent you something that may help you to open it up. Hold on one second. Okay. Do you see something come up? I asked you to start the video. Do you see it?
Joining the website. Wait a minute. Oh,
There should be a bot. Listen, it can't always go perfect. No worries. Okay.
Well, as you know, I dropped off all the notices, public, the affidavits of posting and mailing to your office. Yeah, let me hit it again. Join website in progress. I don't know. Start my video. Got it.
Good.
Let's do it. Can you see me now?
Yep.
Yeah. Oh.
Yes.
Yes.
Yeah, we see you.
Can you hear me?
Can hear you and see you.
Hello,
Okay.
Victor.
Yeah, fine. Finally. Okay.
Sure.
Good. So this is a very minor variance. Is from section 116-5D. The two guys built the pool. They got a building permit from the building department. The survey attached to the building or the site plan was accurate. And when the pool company installed the pool, they did not install it properly. And on two corners, we have a less than 1% variance. Each side is the relief that we're seeking is 1 foot 3 inches on both corners, less than 1%. And of course, that wasn't picked up until after the as-built survey was conducted to get the CO. So that's why we're here for the relief.
I see the 1.3, but I don't know how you're getting less than 1% variance.
Well, it's 20, it's a 20-foot, we're supposed to be at least 20 feet,
Yeah.
and we're actually 18.7 feet, so isn't that like one, well, maybe I did the percentage wrong, but it's 1 foot 3
variance.
inches.
6% variance.
Yeah.
1.3 over 20, it's about 6%.
Oh, I did the division wrong on the.
I was a math teacher, that's the only reason I picked that up.
I did the math. So anyhow, it is what it is. The pool company, of course, the clients did not, the pool company was in error here. It wasn't a hardship created by the applicant, and it has no impact on the neighborhood. And they do want to close it out and get a CO for the pool. So that's where we are.
So it looks like they just got the angle of the pool off a little bit.
Yeah, they cocked it when they installed the pool. I'm sure whoever flagged it or they had it flagged. I guess they didn't follow the flagging that, when they installed the pool company.
Well, the land is not square to the street either.
Right.
If you look at the front yard, it's not square to the street, so I can understand how that happened.
Yeah.
Yeah, everything on this lot is on a funny angle.
Right. The house is on a funny angle, a story garage.
I don't have any sympathy for the pool company, but I do have sympathy for this application for 1 point.
Yeah, I mean, it wasn't like, and the only reason they didn't even.
I don't see, why they shouldn't be granted.
Yeah, again, there's no way they could show up, and even if they showed up and watched the pool being constructed, the naked eye would never pick up an anomaly like this. So it's different if the pool was going, say, north and south, and they just cocked it 20 or 30 degrees. Yeah, it's different. This is a nominal variance. So, and it was only picked up when we did the as-built survey to get the CO.
And the pool's not any larger than was permitted.
No, it's everything else. It was inspected, and it was picked. The pool was inspected by the building department, and then when we submitted the paperwork to get the CO, that's when it was picked up, when the surveyor came and did the as-built survey, and we noticed it was off by 1 foot 3 inches.
Are you the homeowner?
No, I help them out. I do commercial real estate in Riverhead, and I do land use consulting around. I used to be on the Riverhead Town Board for 20 years, so I'm very familiar with all zoning and zoning board of appeals and stuff like that. So this is my hobby now in later years of my life. I could never be an elected official ever again in today's world. I don't know how you guys do it. It's just well, actually, these Zoom meetings are pretty good.
It can be working out. Then it's no meeting at all.
And by the way, I enjoyed the first hearing a lot, with the two houses, the one, with all the litigation. So I used to sit through hours and hours and hours of that stuff.
You mean the one on the ocean?
Yep.
Yeah. Interesting.
You want to do this, approve this tonight, Kevin, or?
If you could, we'd appreciate it.
Fine with me.
It's fine with me as well.
Fine with me.
Okay, do we have anybody from the public who'd like to be heard before we do a decision here? No. Go ahead, Dan. Dan?
But you want to make a motion to approve this relief as requested?
Yeah.
Does David want to put the exact measurements in legal form?
I don't know where David is. We lost him.
We lose David?
Can't lose David.
Hold on 1 second. I saw him in the attendees list. Let me see if I can bring him back.
We do have a current as-built survey that has the accurate, all the description. has,
Sorry.
the description of the pool and everything is certified by the surveyor and stamped. So,
If we attach that to the decision, Kevin, I think we'd be fine.
Well, I can have a written decision for the work session.
You want to do it that way?
Yeah, I don't know if you've ever approved.
Oh, we have.
We used to do them all the time when when Rick DePetris was,
speaking on behalf of the client, I have no problem making a verbal motion tonight and approving this, and then you guys write the decision. I'm fine with it.
All right.
As somebody who's actually participated in something like that over my career and my illustrious career as an elected official, I'm fine with it on behalf of my clients.
Okay.
I trust you guys.
Thank you.
People, excuse me. I'm sorry. People.
That's all right.
Lady.
That's why I can't be an elected official. Oh, God.
All right. So, David, how would you like us to word this?
I'd prefer to have a written decision voted on and approved, but if the board just wants to vote and approve it, that's fine by me.
David, why don't we wait? I mean, it doesn't seem like it's a rush.
All right. Okay.
yeah, just have them wrote it up. We'll close this decision with,
Close it.
yeah, close it for decision.
Right.
So I make that motion.
Do we have a second?
Second.
All in favor?
All right.
Aye.
Very good.
Okay, so then you guys that'll be approved at the work session or another meeting?
David says
Bill.
You can approve it at the work session.
Okay.
We'll do that.
Just so I know, so that for timing wise, because we want to close out the building permit and get the CO.
All right. When is the work session going to be? Have we decided that yet?
I don't know if there's been a calendar date picked for the July work session.
Yeah, I'm not certain of that.
Okay. It'll be next month sometime.
Okay, thanks a lot.
All right. Very good.
Thank you.
Bye-bye.
3070 Sabonic Realty, 50 County Road 39. Do we have anybody for this one?
If you are here for this, okay, great.
Is somebody here?
Yes, someone is here. 1 second.
Sean Lennon?
Okay, you are unmuted. You can unmute yourself. And let me see if I can get you. You see your video to start your video? There we go. All right, we're ready.
Okay. Good evening, everyone.
Good evening.
Sean Leonard, 320 Hampton Road, for the applicant. So this is to seek relief for 11611D7, the transition yard. We have a rare and unusual situation. The property, which is located on County Road 39, it's the laundry mat business, which is located in a highway business district there, and it abuts the R12.5 residential district, which is to the east and also to the south. The property that was to the east originally was privately owned, and it had been sold, and is now currently that property that is to the east and to the southeast is owned by the town of Southampton, and in conjunction with the village of Southampton, for the purpose of being a open space. So what we're coming to you for at this time is that, and since both of those properties are going to remain open space and undeveloped, what we're coming to you is to have the transition yard removed from this property, since we're no longer trying to transition from a business to a residence, since there's really no residence is going to be built there. So we're looking to have that part removed. The new business, laundry business, prior to this COVID-19 has been doing quite well and better than the owners had expected. And we have the need for some additional parking onto the property. So if we could have the transition yard removed, then it would gain us an additional 40 feet of parking to the east on that property, which would gain us somewhere in the range between 9 and maybe 13 parking spots, which is ideally what they need for the use of the building.
Seems like you have a lot of parking right now.
There is a total right now of about 16, 17 spots at the moment. And when the place gets busy, it actually ends up, overflowed with parking. So they need some additional spots. They could use it.
Do the customers actually come in and do their laundry, or do they just drop it off?
No, there are customers coming in and actually doing their laundry.
So it's a laundromat, not just a laundry.
That is correct. It's a laundromat.
Okay.
Yep, there's a total of 50 washers and 50 dryers inside.
So they park their car and they go in and they do their laundry.
Exactly. And on the weekends, mostly, the place is packed. Well, it was packed prior to our COVID-19.
It'll be packed again soon, I guess. Right. I think.
So now it's going to be packed even more. So I've gone by there and that parking lot has been filled, and people go in there, they go in there with, so if there's 16 cars, sometimes there's more than one person in the car. Sometimes they got their children. I don't know, if there are safety issues involved here. It empties and exits onto a major road. Have there been any traffic issues there? Do we know?
No traffic issues that I'm aware of. We actually did an extensive study on that property prior to the construction of that building to make sure that we had, a proper, so you can only enter the property as you're heading east. And when you exit, you actually have to head east out of the property. You can't make a left-hand turn out of that piece of property. And we set the curbing up that way. We worked with the state highway department as well to make sure all of that was done, according to their guidelines and for public safety.
I think we have a letter in opposition from a neighbor, don't we?
Yes.
We did. There was one letter of opposition.
I believe you have two.
Two?
I saw the one. I didn't see the second.
Yeah, though both of those properties would be to the south of this property.
Right.
And so the extension of this has no effect on their properties. We're not looking to encroach or get any closer to their properties with the parking.
Going east, right?
We're heading east only.
What are the hours of operation of this place?
Early.
Yeah, I think they open up in the morning. I'm not exactly sure the exact time. And then they close, I think it's something like 10 o'clock at night.
I think
Oh, that's the only thing that.
I'm sorry.
That impacts the cars going in and out of there, people talking in the parking lot and stuff. I don't know how much that affects the neighbors that to the south of the property.
Well, it is zoned highway business,
That's
Right.
true.
Plus
But
two,
it does border up against residential.
Yeah, but that's, typical of a lot of places.
Yeah.
but the residential piece that we border up to is currently, aside from the ones that are along the south, is, now owned by the town and the village for the purpose of open space. We would still plant along that easterly property line, making sure that we keep it, screened and fenced.
But along the south.
We actually have a fence. We installed a brand new fence, and we screened the south with trees in accordance to the original planning board approval. So all that has been done.
So I don't know what the impact is on these neighbors or the neighbor who's complained, because there's parking here now, is just gonna be a couple more spaces, that's all, a few more spaces, I should say.
Yeah.
In fact, the concern right now is that it's a little bit dangerous when it gets overcrowded because people are trying to squeeze cars in there. They get so crowded.
Right.
And so, the thought is that if we can actually have that additional space, then, you have the safety of being able people to safely park their cars, which actually does help the neighbors.
You turn that down, Sheila? Sheila?
Are you proposing additional screening? Is there a plan for that, or?
We can propose additional screening if you feel that's necessary.
I think the more screening, the better.
Where you're extending this parking lot, does this existing screening go down that way already?
It does. So it runs the entire southern property line. It actually, we screen from the southeast corner to the southwest corner of the property.
Did you say there's a fence and screening?
Correct. There's a 6-foot stockade fence we installed, and we also then put in arborvitaes all along that entire way.
Seems to be satisfactory.
Sean, just take us through, how many parking spaces are there now?
Right now, there is 16 parking spaces.
And you're adding, or proposing to add?
You would give us an additional 40 feet. So for my calculations, that would get us somewhere roughly between an additional 9 to 13 spaces. We kind of
But on the survey that I have, it doesn't show that. It shows you're extending as a hatch to traditional yard. That's the only place that you're asking for the variance, traditional yard area?
Traditional yard. So we would still maintain the 10-foot setbacks from the property line. Actually, in our drawing, I think we're proposing 15 feet was where the parking lot would be.
So some of these spaces you can have as a right, you're saying?
Correct.
Okay. Yeah, then the additional spaces that you're asking for are really,
it's about
they're not going against any neighbor at all.
That's correct.
No, they're not. Do you have anything else from the board?
So I'm just saying that I go by that site every day, probably a couple times a day, and they do seem to keep it clean and neat.
There was another attendee on this application. I don't know if that person is still wanting to speak.
Also, do you think we should add an additional handicap space?
We are doing that. That was part of it. We're actually bumping it up from, there's currently 1, we're gonna make it 2.
It looks like that dumpster enclosure, which is that on pavement, is only 5 feet from the side yard?
I think that's an error there, David. We need to make that at least 10 feet off.
Okay.
Do we have anybody else that would like to speak to this application?
Let me check the list.
No one from the public?
No one's raising their hand.
Okay.
I don't see them on the attendee list, so.
So what's your pleasure?
I'd call for decision if the other board members agree with that.
Yeah, I agree with it.
I'm fine with that.
Mark, you okay with that?
I was on mute, sorry. Yeah, I'm fine.
Okay. You have a motion, Dan?
I move that we close this for decision.
Second.
All in favor?
Aye.
Aye.
Very good.
Thank you.
brings us up to ELC Hillside Investments, 132 South Main Street. This is the barn, isn't it? Is this the barn?
Yeah.
You have anybody here for the app?
Yes, she's on. Tiffany, you're up.
Thank you very much, everyone. Tiffany Scarlato for Burke and Sullivan, 41 Meeting House Lane, Southampton, for the applicant. I think we talked about this a little bit the last time it was on for work session. We're back here. We had received prior approval from this board to reorient the barn to 21 feet, and we asked for a variance for that, and that was granted by this board. We then took the application as approved by this board to the Architectural Review Board, who was poised to deny the application and urged us to come back to the zoning board with an orientation that they thought was more historic in nature. And the orientation that they chose, and we worked with them on this, we were there a number of times. It was not an easy application to deal with. And the orientation that was settled upon was one that was actually, that appears sort of in the same location and the same orientation as the original Sanborn historic map that the village depends on for historic accuracy. So, and I know we talked a little bit the last time about the barn itself being something that is not historic and thereby can be torn down and removed and moved to a conforming location. The argument that we had with the ARB about that was that although not historic in its timbers, so to speak, it was a completely historic restoration and reconstruction of that building and was put back in the same location as it was historically. The problem with the historic location, obviously, is that it's in the flag lot now that the lot has been subdivided.
And just going to have to be moved.
Excuse me?
It's going to have to be moved a little anyway, right?
It does have to be moved either way, and that's a requirement that was part of the lot line modification. So either way, we're going to have to move it. It's just a question of where we move it to. Again, I know you have a letter in your file from the Architectural Review Board in support of the application that you have in front of you. And as far as the standards are concerned with regard to a zoning board application, I would just say that we're sort of in almost the identical situation we were the first time that the board saw this application. There is no change in the character of the neighborhood. What we're doing is actually trying to maintain the historic orientation of the building as per the Architectural Review Board. So it doesn't make any negative change to the character of the neighborhood. In fact, at this point, we do think it does the opposite. Whether the benefit can be sought can be achieved by some other method. I suppose that at the end of the day, we could have reoriented that building, but we have to deal with the Architectural Review Board as well. And the historic orientation of that building on the Sanborn map is as you see it, as it is currently situated, which, as I said, is over the property line, so we're not going to be able to maintain it that way. But the ARB's request is that we bring it as close to its historic location as is possible. And so we literally redrafted the entire site plan based on their request. And whether the variance is a little bit more substantial than we had asked for before, but there is mitigation in that there is no adjoining neighbor. The neighbor is a flag lot, so it's simply a driveway that's a neighbor. On the other side of that, I believe it's a church parking lot. And obviously the variance is not going to have any adverse impact on the physical or environmental conditions in the neighborhood or district. The building has already existed. It's existed there in that location for, I would probably say, more than 100 years. And we're just asking that we be able to move it to another historic location.
So,
and again,
the building is south.
Excuse me?
It runs north-south right now.
Yes.
And
I'm looking at page 4. I'm looking at page 4 of the plans that were submitted.
Exactly.
And it shows a blue square, a red dotted square, and an orange square.
Okay.
And I take it the blue square is where we gave you a variance for. The dotted square is where it is now. The orange square is where the ARB would like it, and they'd like the front of it to face the road.
That is correct. That is
And you're
absolutely-
okay with that? If we were to amend our decision, the owners would move the barn to this location rather than the location that we would? Okay. Kevin, I don't see any issue with this, to do that.
We already gave them the variance to turn it east-west. Now they want to go stay north-south and move it to a conforming location. That's fine.
We left some questions open, Tiffany. Could you knock this?
Oh, I lost you there for a second, but I believe I heard your question, which was, can we knock it down completely?
Do you have the right to knock it down?
Yes, yes, we do. I believe that we do. But again, once we go to reconstruct the building, obviously it would have to be in a conforming location, or we have to get architectural review board. So the building actually has been reconstructed, had been torn down to the ground and completely rebuilt. We had Zach Studenroth from the ARB go out to the property, and I met them out there. And they made a determination that there was not anything historic about the building. So, excuse me. So it was completely reconstructed in the early 1980s in the historic location. And I think the ARB's perspective on it was, we'd like to try to keep it in as historic a location as is humanly possible.
Right. So where we left off, David, was the council for the two boards
Yes.
were going to speak to each other.
Yes, I spoke with.
What we had said was you have to some extent a conflict between the goals of the Zoning Board of Appeals and the goal of the Architectural Review Board. We had already looked at this application and approved a certain location. And at that point, we were done.
Yes, there is definitely some conflict here between the two boards. Ms. Scarlato is correct that this could be knocked down without, I believe that the ARB would need to approve a certificate of appropriateness for that, but that there's nothing that would stop them from issuing that certificate, given that it's not an actual historic structure. The property is a historic structure, and to keep the orientation with a carriage house of this size and the residence is why they want to keep it separated from the main residence. So as Ms. Carlotto said, if they did knock it down, they would have to go to the ARB and propose something that was smaller, that would comply with the minimum requirement on the code the maximum requirements in the code for accessory structure size. And that's, I believe leading to keeping this structure and relocating it.
I thought that would have been our purview, retaining the existing size, because that was a topic of conversation when we heard this case as a variance application. We decided that retaining the size was acceptable to us as long as it was relocated.
Yes, I'm saying if they knocked it down, they couldn't build a structure of this size again.
They're not going to knock it down.
I thought we had said they could.
No, but they're not going to knock it down.
My understanding is that we've reconstructed the building once already. My understanding is that it could be reconstructed.
I'm in a different location.
Mm-hmm.
You're saying if they just completely knocked it down,
Right, obviously.
they could do that.
Right, but no one would ever do that because.
Right, nobody would do that.
No one would ever do that in a sane moment.
So
to
as I said,
meet the setbacks?
To reconstruct this structure, they could move it and keep this size.
We're getting off the topic here. We're not going to reconstruct it. The question is, where they propose to move it to, does it meet the setbacks?
No.
No, that's why we're here.
That's why you're here. Okay.
It's more non-conforming than was previously approved.
To a conforming location. So our goal was to have structures conform with dimensional requirements.
Right.
And what the ARB is saying is, no, we're asking that you grant a variance so that it can stay where it is, essentially, in the orientation that it is, even though it's in the setbacks.
Right.
And the reason why I thought council was going to talk to each other is because it's a question when you don't even have an historic structure, as as to why, you know, why we would be having that conversation.
This is a historic property. The whole property is in the historic district. So any building that's built on this or demolished on this property needs to go in front of the ARB. No matter.
And honestly, what we're looking to do at this point is to bring, and what the Architectural Review Board asked of us was to try to make the property as historically accurate as possible. And you know, it's something for the zoning board to think about, I suppose. You know, is historical accuracy, you know, as important as setbacks,
listen,
particularly
maybe we
when
should
it's right
go
next
back
to the
to-
flag lot.
So they're asking for more relief than the relief that we gave you originally to put the building in the position they wanted. But there's no harm, no foul, because it's against a flag lot and it's against the parking lot of a church. So there's like no harm, no foul to grant the additional relief, because you're not harming anybody, but you're keeping a building maybe a little more historically accurate.
But then, Dan, why did we not approve the variance in the first place?
Well, I think what happened, maybe the ARB should have spoken to it while we were hearing the case rather than after. It's just that it didn't happen that way.
Right. I think that's an internal issue that you know, I don't want to get caught in the middle of. Unfortunately, the client got caught in the middle of. But, you know, so here we are being bounced back and forth. And the client at this point just wants approval to move on. Like I said, we reoriented the entire site plan.
I sort of see it as housekeeping.
Yeah.
I think there is an attendee who perhaps wants to be heard on this application.
Who do we have?
William Freeman. Hold on one second, let me get him in.
Because we did, the board did grant variances for 20 feet setback where 30 feet was required.
Did.
Right, so we minimized the required relief. And now the relief would be what?
Sorry, it's 21 feet from the property line where 30 foot was required. And now it is.
We're asking for 5 feet and 262 cubic feet of pyramid relief, because we're backed into that corner as the flag lot driveway sort of jogs off to the right. We're backed into that corner there.
All right. We have Mr. Freeman here?
Yes.
Yes. Hi, William Freeman. My mother is Elaine Freeman at 132 Post Lane. And you've answered most of my questions. I was not sure where the proposed location of the barn was going, and if it was going to impact the southern boundary of my mother's property. But it sounds like it's more adjacent to the St. John's Church parking lot. As such, as long as it's not, you know, on the southern border of my mother's property, I have no objection.
But still on the northern side of the property.
Right.
You said Freeman, that is just in the north side of this property where the jog is for where that little section of the turn-in is on the north edge. I believe that's where the Freeman property is, according to your survey.
Right, it's the very last on Post Lane.
Looks like it's right behind the church.
Correct. So it doesn't look, I haven't seen the map, but it's not going to be in a direct view of the southern border of 132 Post Lane, correct?
It's actually not moving all that far from where it was originally located. I don't know if me showing this to you is going to help on camera.
If you could hold it up, I'd love to see.
Yeah, that's no problem at all. I don't know if you can make that bigger so you can see the orange box is, oh geez, I have to pull back and look, is the proposed placement. The red box is where it is currently located, which sits in the middle of the flag lot. And the blue box is where the zoning board had approved it previously. So if you can see that the red box is where it's located currently, and we're going to be moving that slightly My directions are messed up now.
East.
Slightly
Closer to-
southeast.
Okay, so closer to South Main?
Yes, closer to
Okay.
South Main.
Okay.
Actually, a little
No,
further
no.
away from South Main. I'm wrong.
Well,
The other direction.
It's closer to your property.
Okay, will it be in the view plane?
Probably is now.
It probably is.
Well,
at
I mean,
this
we can
point,
see it in
yeah.
the distance, but it's off to the side.
Right, and keep in mind that it's currently a vacant lot in the back, but it is a buildable lot. Right now, there's a tennis court that straddles that line that is permitted to remain in that location. But that flag lot does lead to a buildable lot in the back. So you're, Mr. Freeman, just to be correct, you're the lot behind that on Post.
It looks like it's about 16 feet closer toward your property, which is like the length of a car.
Okay. All right, no objection.
Thank you.
We have anybody else who'd like to speak?
That was the last of the attendees.
What's the feeling of the board?
I have no problem amending our decision.
So you want to close this decision?
I don't know how the other board members feel.
I know, well, we're going to find out.
Okay, so let's close the decision.
Mark and Julia,
We can close it for decision.
that's your motion, Dan?
I make a motion that we close this for decision.
Do we have a second?
I'll second.
All in favor?
Aye.
Aye.
Thank you.
Aye.
So it's closed. Do we have one more application before us?
I think that's it.
What about
We
three?
have
Did that get,
Narrow Lane, number 3072.
what about Narrow Lane? Did that get withdrawn?
It was.
There was a
withdrawn.
letter saying
They
that,
found
I
another
saw a
location.
letter that it was being withdrawn.
Yeah.
Oh, okay. My apologies.
So Narrow Lane is gone.
Yes, they found a conforming location.
So therefore, it looks like we're done.
Well, do
Yeah, I think that's it.
I think really we should thank our facilitator who organizes this meeting and gets everybody up and everybody down. It must be a very hard job for her to do.
are we? I'm just curious. Sorry, before on 3072, they filed affidavits today for notice and posting. I don't have in my file
Well,
I read a letter. It
Okay.
came this afternoon that they had withdrawn it.
Oh, okay.
I just, everybody, I mean, I received it via email. Everybody should have received the same letter.
Yeah, that's how I got it. I read it this afternoon.
On the list that Julie provided of who was going to be on tonight, there's no one scheduled for this application for Narrow Lane. So I'm not sure if that proves anything one way or the other, but there's no one here for that application.
Okay, so it couldn't proceed anyway, so.
Yeah.
all right. So, are we ready to close the meeting?
I came back to say goodbye.
Oh, hey, we just moved on.
Yeah, if somebody could forward me that that letter on 3072, because I don't have it in my file, but I believe all of you, so.
All right. So I move that the June 25th Zoom meeting of the Southampton Village Zoning Board of Appeals be closed.
I'll second.
All in favor?
Aye.
Aye.
Good night, all.
Thank you all.
Good night, everybody. Thank you.
Nice to see everybody. Take care.